In conclusion, therefore, upon careful consideration of the consolidated petitions, the responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the Deputy President. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, Sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
I will deal with the aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various reliefs arising from the partial success of the consolidated petitions. Our jurisdiction to issue such reliefs is firmly anchored in Article 23 of the Constitution, which empowers the court to grant appropriate remedies for the enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 2, Subarticle 4, orders of compensation, and orders of judicial review. The courts have, over time, provided guidance on the considerations applicable in granting constitutional reliefs. In affirming that a court is not confined to the remedies expressly enumerated under Article 23, the Court of Appeal in Total Kenya Limited versus Kenya Revenue Authority 2013 reported, held that even where specific reliefs are expressly provided, a court is not precluded from issuing any other orders under the inherent jurisdiction, as long as such orders are necessary to ensure that justice is done between the parties. In the same vein, the High Court in Simeon, Kioko, Kitheka, and 18 others was the county government of Machakos and others, held that Article 23 of the Constitution does not expressly bar the court from granting conservatory orders where the constitutionality of legislation is challenged. Similarly, in Republic versus Ex parte, Chudasama, the court emphasized that courts retains inherent jurisdiction to fashion appropriate remedies to secure the ends of justice. Speaking to the nature of appropriate reliefs, the Constitutional Court of South Africa in Force versus Minister of Safety and Security said as follows, and I quote, appropriate relief will in essence be relief that is required to protect and enforce the Constitution. Depending on the circumstances of each particular case, the relief may be a declaration of rights, an interdiction, an interdict, a mandamus, or such other relief as may be required to ensure that the rights enshrined in the Constitution are protected and enforced. If it is necessary to do so, the courts may even have to fashion new remedies to secure the protection and enforcement of these all-important rights, end of quote. Regarding declarations and damages for constitutional violations, the Court of Appeal in Gitobo, Imanyara, and others versus Attorney General, report in 2016, emphasized that constitutional remedies are not confined to declarations alone, but may extend to compensatory relief where rights have been infringed. The court observed that damages serve not merely as recompense to injured party, but also as a means of vindicating the Constitution itself, and ensures that violations are met with effective and meaningful redress. In referring to Lord Nichols at paragraph 18 and 19 of that decision, the Court of Appeal affirmed the position that, and I quote, when exercising this constitutional jurisdiction, the court is concerned to uphold and vindicate the constitutional right which has been contravened. A declaration by the court will articulate the fact that the violation, but in many cases, more will be required than words. If the person wronged has suffered damage, the court may award compensation. The comparable common law measures of damages will often be a useful guide in assessing the amount of this compensation. But this measure is no more than a guide, because the award of compensation under Section 14 is discretionary, and moreover, the violation of the constitutional right will not always be conterminous with the cause of action at law. An award of compensation will go some distance towards vindicating the infringed constitutional right. However, how far it goes will depend on the circumstances, but in principle, it will not suffice. It may not suffice. In fact, that the right is violated was a constitutional right adds an extra dimension to the wrong. An additional award, not necessarily of substantial size, may be needed to reflect the sense of public outrage, emphasize the public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and to deter further breaches. End of quote. All these elements have a space in this additional in the additional award. Redress in Section 14. Sorry, that's still the quotation, which I did not go through it. In this present case, and against this background, and having found that the rights of His Excellency Gachagua, were infringed, it is our considered position that declaratory relief and reasonable damages ought to be granted, not only to address the injuries suffered, but also to vindicate the Constitution and deter future violations. We now turn to examine the efficacy of the other reliefs. The petitioner sought an extensive range of remedies. In total, 49 declarations were prayed for, distributed across several thematic areas. 9 declarations relating to public participation, 15 declarations touching on the impeachment motion and process, 3 declarations on the fair hearing and due process, 3 declarations concerning the Senate proceedings and committee process, 2 declarations on standing orders, 1 declaration on the National Assembly and the gender representation, 8 declarations on the appointment of His Excellency Kindiki as Deputy President, 5 declarations on the vacancy in the office of the Deputy President and the nomination process, 2 declarations on violation of voters' rights, and 1 declaration regarding the members of the NIS. Beyond declaratory relief, the petitioners also sought 5 orders in the age of certiorari, 2 orders of mandamus, and 2 injunctive orders. They further prayed for reinstatement of His Excellency Gachagua to the office of Deputy President, an order for apology and cause. In addition, there was an elaborate prayer for damages and compensation. In considering the relief sought, it is evident that the two prayers have become moot. The first is the injunction that seeks to restrain the President, National Assembly, and any other state organ from proceeding with or effecting the appointment of any person to the office of the Deputy President pending the hearing and determination of the petitions. The second is the conservatory order restraining the respondents from collecting signatures, lodging any motion, or conducting any proceedings seeking to impeach the Deputy President. For clarity, these prayers are disallowed. Regarding the relief seeking the reinstatement of His Excellency Gachagua as the Deputy President of the Republic of Kenya, we do note that His Excellency Gachagua, through his pleadings and submission by his legal team, expressly abandoned the quest for reinstatement and indicated that he was no longer interested in pursuing it. Nevertheless, since other petitioners continue to press for the said relief, it remains necessary for this court to pronounce itself on the matter. Article 145, subarticle 7 of the Constitution provides as follows, I quote, "If at least 2/3 of all the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office." This provision speaks to the finality of the Senate's resolution once it upholds an impeachment charge. Upon such resolution, the president or deputy, as the case may be, stands impeached and ceases to hold office. The constitutional text is categorical that the cessation of office is automatic and does not require any further act of implementation. The impeachment resolution, once validly passed by the Senate, is self-executing and a fait accompli. The constitutional design is deliberate in this respect. It does not envisage an instance where the impeached president or deputy president may be reinstated within the framework of the presidency. The vacancy resulting from the impeachment resolution can only be filled through the procedure under Article 149, Sub-Article 1. Even in the unlikely event that Parliament and the President wish to return the impeached office bearer, such a cause will still be subject to the availability of the vacancy and the nomination process prescribed by the Constitution. To hold otherwise presents profound constitutional and practical difficulties. The office of the Deputy President is not merely a matter of judicial declaration, but is intertwined with constitutional processes, political accountability, and the functioning of the executive. To order a statement in circumstances where the vacancy has already been filled would amount to the court usurping powers reserved to the people and their representatives under the Constitution. It would upset the delicate balance of separation of powers and create a constitutional absurdity. For the Constitution does not envisage two serving deputy presidents at any one time. The court cannot undo what the Constitution itself declares to be conclusive. Reinstatement, therefore, is not a viable or appropriate relief in the circumstances of this matter. Before leaving this subject, we find it necessary to acknowledge and comment on the doctrine of constitutional dilemma that arises in these proceedings from the tension between the constitutional finality of impeachment and the vindication of rights. This tension is highlighted by the comparative jurisprudence, most notably in the United States, where courts have adopted a principle of total avoidance, treating impeachment as non-justiciable. Yet our own constitutional framework demonstrates that avoidance cannot resolve the question that persists. In view of the recurring tension, a constitutional amendment clarifying the scope of impeachment finality and the role of judicial review may be warranted. At this juncture, we also find it necessary to distinguish the process of removal of a county governor from that of the president and the deputy president. To begin with, Article 181 of the Constitution sets out the grounds upon which the county governor may be removed from office. They are gross violation of the Constitution or any other law, B, serious reasons to believe that the governor has committed a crime under national or international law, C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of the office. Article 181, Sub-Article 2, assigns Parliament the responsibility of enacting legislation to provide for the procedure for removal of a county governor. That legislation is the County Government Act, which we'll be referring to as the County Act in this discussion. And Section 33 thereof prescribes the detailed procedure. It provides for initiation of a motion in the County Assembly, transmission of the resolution to the Senate, investigation by a special committee, the governor's rights to be heard, and ultimately a vote by the Senate delegations. If upheld, the governor ceases to hold office. If rejected, the motion may only be reintroduced after 3 months. When this process is juxtaposed with the removal of a president and deputy president, and Article 144 and 145, several key differences emerge. First, whereas the president and the deputy president may be removed either on grounds of incapacity or impeachment, a county governor is removable only on the 4 grounds enumerated in Article 181. Section 33 of the County Act, however, introduces impeachment terminology, thereby expanding the constitutional parameters in a manner that is troubling. Second, the removal of the president and the deputy president is provided for directly in the Constitution, while the removal of a governor is legislated under the County Act. This distinction is critical. Under Article 2, Sub-Article 4, legislation is subordinate to the Constitution and may be declared unconstitutional by a court, whereas constitutional provisions themselves cannot be impugned. Thus, while the Senate vote under Articles 144 Sub-Article 10 and 145 Sub-Article 7 is final and beyond judicial review, the Senate vote under Section 33 Subsection 7 of the County Act is susceptible to challenge. Courts may proceed to stay and quash a resolution to remove a governor and even halt the filling in of the vacancy, but such judicial interventions cannot be imagined in the case of a president or the deputy president. Third, the manner of filling in the vacancies also differs. Under Article 149, a vacancy in the office of the deputy president is filled by presidential nomination and voting in the National Assembly, whose vote stands final and is self-executing. By contrast, the Constitution does not prescribe how a vacancy in the office of deputy governor is filled. Section 32D of the County Act provides for nomination by the governor, approval by the county assembly, and appointment thereafter. This statutory process, unlike the constitutional one, is amenable to judicial review and may be stayed or quashed. It is therefore on account of these glaring differences that this court cannot apply mutatis mutandis, the jurisprudence on removal of county governors to the removal of the president or deputy president. We nonetheless affirm that where binding judicial findings on governors' removal are squarely applicable to issues before us, we cannot run away from the same. This includes the pronouncement by the Supreme Court on the second case on the choice between plenary or special committee. In sum, therefore, whereas Article 144 and 145 embodies what may be termed as constitutional finality, the provisions of the County Act represent a form of statutory finality, thereby actuating the distinction between the two. We now turn to His Excellency Gachagua's quest for pension and emoluments under Retirement Benefits Act. The preamble of the Act makes clear that it is an act of Parliament to provide for granting of pension and other emoluments, retirement benefits to persons who hold the office of Deputy President and persons who have served as Prime Minister, Vice President, Speaker, Deputy Chief Justice, or Chief Justice after 1st of January 1993 and for connected purposes. Section 7 of the Act provides for the pension and other benefits of a retired Deputy President or a retired Vice President. Section 2 defines a retired President as a person who, having held the office of Deputy President, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a Deputy President who ceases to hold office by reason of impeachment can be deemed a retired Deputy President within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the Deputy President by impeachment. We find this prayer to be merited. For clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is a vindication of His Excellency Gachagua. We, however, hasten to add that the violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, Sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitwabu Imanyara's case, it is our position that the violation of His Excellency Gachagua's fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, For the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
When her leadership, the Justice Dr. Mugambi, was reading part of the judgment, if I heard correctly,